I think one reason we're sitting here kind of smiling at this reception, obviously Justice Stevens is a rock star in this crowd, and we had a similar conversation just about a year ago at Yale Law School, where everybody was very respectful and very appropriately admiring, but there was a certain academic stillness in the room when we began our conversation. As Alan mentioned, Justice Stevens came out 2 years ago now, a very interesting memoir, Five Chiefs, which does give a lot of insight into how he has seen his role on the court and very astute observations about the court. And I want to play off of one of those to get us started. You say in the book that, in your opinion, the most important thing that happened during the Chief Justiceship of William Rehnquist was the retirement of Thurgood Marshall and his replacement by Clarence Thomas. And so I wonder whether you would make the same kind of definitive assessment of the impact in this Chief Justice's tenure of the retirement of Sandra Day O'Connor and her replacement with Justice Alito. The difference between Clarence Thomas coming and Sam Alito coming.
No, I really think there's a world of difference between those two, because there's really a dramatic change in Clarence's viewpoint on many, many issues, and it cut through a whole series of issues. But what I was going to say when you mentioned that was that one thing that occurred to me during that transition year is that the law really should provide that the justices who heard the argument in a case should continue to participate in the case even after they resign. And in that particular term, there were 3 or 4 cases that Sandra had heard the arguments, and it seems to me we should have just gone ahead and decided those with her having the right to vote even though she was a retired justice. Because as you know, in many state courts, a retired justice may serve to fill in a vacancy or something of that kind. And I would think a transition would be more orderly if you did not interrupt that by canceling out what had heard before and then substituting the new member of the court. And I can't comment on whether the results were different in particular cases, but it did occur to me that that should be the process that's followed. And I also would say that although there certainly is a difference between Sam's work and Sandra's work, it's not nearly of the same magnitude in my judgment. I think he's made written a number of fine opinions, and there are also cases in which I'm not sure the result would have been all that different.
Of course, speaking of Sam Alito's opinions, you came out in great support of his dissent in the Westboro Baptist Church case,
yes,
as I recall.
Yes, I did, because it seemed to me that the same distinction that applies in the area of libel and slander between a public figure and a non-public figure should also apply with respect to the tort of an intentional infliction of emotional distress. And if you applied that distinction, the plaintiffs in that case should have been entitled to recover.
Of course, that case came down after you had left the court. And do you still read every opinion?
I do. I've not read a couple that just came down, but I find it interesting reading, and I don't know.
It's more than most people in this room, I'm sure.
Yeah, right. But yes, the answer is yes.
And you not only read them, but you ponder them and you form opinions about them. In preparing for this, I looked on the court's website the other day. There's a part of the court's website that posts speeches by members of the court. And I thought, well, I've heard that you've been sort of up and around and speaking, and I'll, maybe check in and see where all you've been. So of the last 17 speeches listed on the Supreme Court's website, 16 of them were yours. So
I
this
hope
is,
they got more attention than some my dissents did.
well, I'll mention one of them. Actually, your most recent one, I think, was your talk at Brandeis, or your talk to your talk at Louisville, the
Yes.
Brandeis lecture, where you criticized the court for indulging in too many what you called glittering generalities. And I want to give you an opportunity to, people who didn't hear that talk, and probably not too many people have read it yet.
Well, the glittering generality that I was really thinking about in that particular talk was the statement in Buckley against Vallejo, which is sort of the backbone of the Citizens United holding, that one of the most fundamental rules is that the government may not censor speech for the purpose of enhancing the ability of either side of the debate to advance his cause, which is a perfectly sensible and reasonable approach to most debates about public issues. But to suggest that there should be a rule that prohibits the regulation of campaign debates, it seems to me quite unwise, quite unnecessary. It just seems to fit into that glittering generality. And I really think the heart of the Citizens United decision, and the unfortunate part, traces itself back to that part of the Buckley decision, which I really think should be re-examined. It was part of the holding to the effect that the First Amendment prohibits government from regulating expenditures, the amount of money that can be spent on speech. And I really think that's at the heart of the present problem. I don't think it's just merely important to be able to regulate corporate spending and union spending and the like. I think it's important to be able to regulate, put ceilings, reasonable ceilings, on expenditures by anyone who wants to influence a political campaign.
And of course, that glittering generality has been, the court, far from receding from it, has really extended it. And that Arizona campaign case that the Chief Justice wrote a couple terms ago, where you couldn't enhance the public financing for the poorer candidate just because the richer candidate was spending more of his own money. That would be an application of the same kind of glittering generality.
I think that's true. Yeah.
Are there other equally pernicious glittering generalities around and about? I mean, I could think of one, but I don't know whether you would agree. Something like the way to get beyond discrimination by race is to stop discriminating on account of race. Would that be a glittering generality?
Yes. I think it is. I don't know if it was, we had when Linda and I were last together at Yale, they had a moot court about the case, and it's now before the court. And one of the questions that I asked one of the students is why he failed to cite that particular statement in his brief. Because after all, he's pretty respectable authority. The Chief Justice of the United States has expressed that view. And I can't remember what the answer was. Do you remember, Linda?
I think that student was pretty taken aback.
I guess that's right.
I don't quite remember.
I guess it was an unfair question.
Well, but I mean, let's talk about Fisher a bit. Of course, neither of us knows how it's coming down. It's coming down soon. So there was Sandra O'Connor in the Grutter case 9 years ago, 2000, well, 10 years ago now, 2003, saying, you know, we don't expect we're going to have to get back to this issue for another 25 years. We find a compelling state interest in diversity in higher education. We find this kind of affirmative action sufficiently narrowly tailored to meet strict scrutiny, and, you know, basically, goodbye, don't bother us again with this for the next generation. But yet, here we are, within weeks we're going to get some, let's assume, modification, to put it mildly. So what does that tell us about the court that you left?
Well, I guess they are less controlled by stare decisis than has been true in the past. And it's interesting, Justice Thomas, who incidentally is a very nice guy, and I'm very fond of him, we're good friends, but he certainly is not a fan of stare decisis. If he thinks there was a mistake made 30 years ago, he's willing to correct it right now. And I do think there was no conflict, there was no need to take the case, so it is, we don't know how it'll come out, but it's an unusual case.
Yeah. You wrote, during your 3 decades on the court, you wrote more dissents than any justice in history. I have the numbers here. You wrote 720 dissents. That's the most ever.
I think that number, which is always embarrassing, should entitle me to the Lifetime Failure Award.
No, history is long, as the young William Rehnquist, the junior William Rehnquist dissents ended up as majority opinions. You know, the worm can turn, but just because people seem to like that number, 720. So the second most, I'll read this just because I happen to have it here. Second most number of dissenting opinions was William O. Douglas with 486 compared to your 720. So what about the dissenting opinion as a work of history, a work of art, a work of emotion, anger? You've expressed some of those too.
Well, I don't know. I've often said that every case is different. You always start from the beginning when you're working on a case, and the same of true dissents. Every dissent is different, and the cases present different problems, and you react to different cases in different ways when you set forth your views about the cases.
Of course, everybody remembers your dissent in Bush against Gore, and your former colleague Sandra O'Connor seemed a couple weeks ago to be having some second thoughts about Bush against Gore, or at least the impact of it. I wonder if you have any did that bring back any memories for you?
Well, of course, there are memories of it, but also I have to confess that in the recent years I've thought a little bit more about the rationale for the per curiam decision in that case. And the rationale was really quite unacceptable because there was a violation of the Equal Protection Clause by treating hanging chads differently from dimpled chads. And the difference between the two, of course, is absolutely zero, because when you punch a ballot and you do indicate for whom you intend to vote, whether you make a dimple or you make it a hanging chad, or you do what is required to have the machine count the vote. And I've often reflected on the notion that there should be a distinction of constitutional magnitude between dimpled chads and hanging chads, and I find it quite hard to accept.
Was that an argument you offered around the conference table?
No, it is not. I didn't. What I had to say is pretty much the same thing I said in my dissent, which goes to the propriety of the court weighing in on an issue with the state courts had addressed quite competently.
And that seems to be what Sandra O'Connor is now having some second thoughts about. She said she now thinks maybe the court shouldn't have taken the case in the first place. Were you surprised to hear her say that?
I didn't hear her say that,
okay.
but I'm pleasantly surprised, yes.
We know, of course, we've memorized your Citizens United dissent. It's on a big plaque, but a key of it is a big plaque in the other room. But are there other dissents of yours that you're particularly proud of?
Well, there are, I'm sure, but there are too many to name right now.
Well, one that you single out in the book, and I know it's a case and it's an issue that you feel very strongly about, was Seminole Tribe and the whole sovereign immunity question. If you want to reflect on that a bit. You considered that one of the most unfortunate of all opinions during the Rehnquist era, I think.
Yes, well, I think it's perhaps the most significant opinion that he wrote during his tenure. But It's quite wrong, and one thing I have learned in reading a little more about that issue is that the case that many critics of the sovereign immunity line of cases single out as primarily responsible for that development law is Hans against Louisiana. But in fact, the Jumel against Louisiana case, which came a few years earlier, is the real culprit in the case, because that's the case in which the court abandoned Justice Marshall's interpretation of the 11th Amendment, which had been the law for ever since Marshall was on the court until after the Civil War.
So much for originalism, I guess.
Pardon me?
So much for originalism.
Absolutely, it is. But the real interesting thing about the Jumel case is that it probably came out the way it did because the Northern troops had been withdrawn from the South at the time. And I think there was an underlying fear that the court would not have been able to enforce its judgment against a southern state which was no longer being dominated by the federal troops at the time. And I think as a matter of study, it'd be interesting to take a good hard look at that period of Reconstruction.
Do you have the time now to kind of delve into that sort of history that you wouldn't have had?
Yes.
Time? So are you reading a lot of history now?
Yeah, so I'm learning a lot, not only by reading it a lot, but I read 2 or 3 times Charles Lane's book on the day freedom died. I think it's about the Cruikshank case. Those who have not read it should read that book because it, I think, will clarify one fact that people generally make an incorrect assumption about, and that is whether the Republican-dominated legislatures in the 10 years immediately after the Civil War were in fact competent legislatures or not. And in fact, the Louisiana legislature enacted several statutes that would have been regarded as models of legislation if they were enacted today. One of them commanded integrated schools for both African American and white pupils. Another became the cause of action to a person who was discriminated on public transit, gave rise to the Hall Against a Cure case, and there are other statutory provisions the legislatures adopted that merit respect.
Another one of your dissents that I always found particularly, I won't say charming exactly, but vivid, was Scott against Harris, the police chase case. People may not know that case, but it was a case about whether a police chase of a speeding car that ended disastrously with forcing the driver off the road with horrible consequences, whether it was so unreasonable as to violate due process. And the court had it in its possession and put up on its website a video of the chase, and 8 justices said the video proved that the driver was driving so dangerously that the police were justified in taking him out, and you were the lone dissenter.
And that was really a terribly unfortunate decision. The reason that it came out that way, I think, is that when one looked at the video, and that the members of the court, including myself, doing it independently, looked at the video without the guidance of trial counsel pointing out certain important aspects of the chase. And when you just look at the video, it's frightening because it is a video taken from the driver of one of the police cars chasing the young man who had not stopped when he was commanded to. He should have stopped, of course. But you see these cars being forced off the road, one after another, which is really a frightening display. But the problem was that you could not hear the sirens on the police cars, which obviously gave notice to the people who were approaching and gave them plenty of time to get out of the way. So that the appearance of a terribly dangerous chase was most misleading if you couldn't hear the sirens and didn't have in mind that they had adequate warning to avoid the risk. And I think it was really a most unfortunate example of appellate judges trying to act like trial judges. They were acting on a record without the guidance of the witnesses and the counsel who would be able to comment on what they were seeing. And I really think that video was what turned the case around, because after all, both the trial judge and all of the members on the Court of Appeals had thought that whether or not the stop was reasonable was a jury question that should be decided by the jury. I felt very strongly that was right. That's a dissent I feel quite strongly about.
Well, it's kind of ironic because the technology, the video, which one would think in the abstract would have clarified the situation, ended up by obfuscating the situation.
That's exactly right. I think it's true.
And I remember when I first asked you about this, soon after the case came down, you said to me, well, you were the only member of the court who actually knew how to drive.
Well, I did, and of course I learned to drive when it was mostly two-lane highways, and you had to pass, be careful about passing not on a hill and that sort of thing. And I don't think my colleagues had the same experience. That's one of the advantages of learning to drive in the 1920s and 30s.
Since we last spoke, of course, the healthcare case came down. Were you surprised by any aspect of it?
No, it's really odd. I don't have a particularly good record of predicting outcomes of cases. But that morning, Dina Mishra, my clerk at the time, and I were talking about the case, and I had been planning to interview a new candidate for law clerks that morning, and the case came down a day later than we expected the court to adjourn. So I was there at the court for interview purposes, and at the last minute decided to go and hear the case announced. It's the only time I've heard an announcement since my retirement, by the way. And that morning I told Dina that I predicted that the vote would be 5-4 and that the chief would make the deciding vote. And I told her that I was confident in the chief's, regardless of his own personal views, and I'm sure he was not happy about the outcome, that he would follow what he thought the law required. And I was right on that one. So I did predict that case correctly. And I can't brag about that very often, but that one I did.
And what made you think that? What about your knowledge of the chief made you think that?
Well, as I say, I do think he's intellectually honest, and he calls them as he sees them. Often I disagree with his views, but I think he is totally believes that he must do what the law requires. And I thought in that case it was quite clear that the law did require that result, and that was enough for me to predict his vote on that basis.
Of course, I'm just guessing that you probably thought both not only the congressional tax power required that outcome, but I doubt if you thought very much of the Commerce Clause attack on.
No, I do not agree with his analysis of the Commerce Clause in that case. I can't comment on that, but anyway, on the bottom line, I did agree with it.
Right. So that was the only time you've been in the courtroom since you retired, but you...
Only time when the court's in session.
Of course, it's right. Yeah. But you certainly sat through or participated, as Alan mentioned, plenty of oral arguments. And do you want to talk a little bit about the utility of oral arguments? Some people say, it's just kind of a show, and what's the point? Do minds ever change? Does anything really come out of it? And what's your experience with it?
No, the oral argument is really a very important part of the process. It often changes not merely the result, not too often the result, but it often changes your analysis of a case and your consideration of the significance of particular issues and the like. And I know it has affected my thinking on many occasions, and there are arguments that have turned the court around, too.
I get a signal that we're running out of time, so I'll just ask you one last question. You were appointed to the court by President Ford, and your nomination sailed through, I think, in just a matter of weeks, right? And you've been around long enough to see what's become of the confirmation process for really all the federal courts, and I just wonder whether you have any thoughts about what's been happening.
Well, of course, one of the major changes is the fact that the hearings are now televised. They were not televised in 1975, was it, when I went through the process. And because it was not televised, the first day of the hearings, Edward Levy said a few words about me. The head of the ABA section on judicial nominations did, and the two Illinois senators said a few words about me, and that took probably 5 or 6 minutes. And then they started questioning. Today, the first day, as you know, is devoted to speeches by the senators explaining how important the hearings are. And I think most people would know that, even if the senators didn't find it necessary to tell them at the time. But that certainly made a difference in the process, the television process.
Well, I don't want to stand in the way of you getting your awards that you're about to get from Public Citizen. So I'm just going to thank you for being up here and being willing to talk with me.
Well, thank you. I've enjoyed it.